Karibu sana, thank you very much for sticking around. This is Morning Cafe. I'm yours truly, Stanley Nyirungita. I hope umeamka salama and you're having a fantastic day today. On Law Matters today, in Kenya, succession matters can be quite controversial. The cases can drag in the corridors of justice for years on end. Actually, just recently, the High Court ordered that all parties involved in the multi-billion succession case of the estate of the late former president, that is Daniel Moi, appear before it on the 7th of October, Imwaka, this year. So this morning we help you understand the process, the do's and don'ts while applying for succession and who is supposed to do this. We also invite you to call us live for all the questions you have regarding this topic, because it definitely affects a number of communities in the country. You find that your relative passed away and then now the surviving people who are there are really trying to sell and interact with the property yenye huyu mtu wenu aliacha. What do you do for that? Tupigie simu. The number, will be seeing it on your screen. And we have the right person for this conversation. This is a part 2 of what it started last week. There's so many callers, there's so many questions. Watu walikuwa wametuma maswali, so hata wewe unaweza tutumia maswali na wakili atakuwa na jibu. Another new face to this conversation, Advocate Silas Akiro. Karibu sana.
Thank you so much, Stanley. Good morning.
Good morning to you. Obviously, every single morning we have new viewers.
Yeah, exactly.
Na mtu kuangalia naona kuna mwenye amekuzoea, kuna mwingine anakuangalia naona who is this guy?
Sure.
It would be good to give us a brief intro.
Yeah, sure. My name is Silas Akiro. I'm an advocate of the High Court of Kenya. I practice in the manner and style of Akiro and Associates Advocates. We are based at Westlands and Kipro Center. We handle quite a lot of succession matters. Really, that is not the specialization to say, but we have quite a lot of succession matters across the country. We have so many up country and a lot more within the city, including Kisumu and Mombasa.
Yes. Right. One of the questions we got just right off the cuff before we really, because I know we'll dive into the details.
Yes.
Law of Succession Act. Tutakuwa tunaangalia katiba inasema nini ndio tuelewe, but then just to help us understand what people out here are saying, tusiende into kizungu nyingi ya law sana, ndio pia ukiwa nyumbani unaelewa what we're saying. So the question that we got last week, someone is saying, good evening, alikuwa ametuma majioni, wife to the deceased bought land and was being used by the family. Will it be subjected to succession as part of the deceased property? This is just a number of the questions we've got. Can a grant be revoked if an application for revocation is made after 12 years? Hi, my name is Kimwayo from Karatina. I think we can even just beginning with the stats. Now, as you do
sure.
that as well,
Sure.
tuambie the whole process.
I think we had touched that question, particularly the one on revocation of grant. And then I said that succession in Kenya is unending. I know there are certain jurisdictions that have put a cap on an end to succession where after 2 years of confirmation of grant, if there is no application or summons for revocation, then you will not be allowed to open that file again. But then I gave an example where we are currently handling a case that was closed in 2002.
Okay.
In 2024, of course, that is more than 22 years. And so grant can always be revoked at any given time, so long as it can be established that Section 76 of the Law of Succession Act was abrogated, or rather was not carefully followed. When it comes to the wife of a deceased bought land, can it be subjected to succession? Well, that is no, because a succession deals with estate. In Swahili we call it mali ya mwenda zake, the estate of a deceased person. Now, the wife here is still alive. And the husband is the one that probably has passed on. And so what the wife has acquired in her name, that will not be subjected to succession. That is usually just subjected to the normal property laws. If it is land, and then we have the land laws.
So what if it has a tie to the deceased? Because as this person rightfully asks, the wife to the deceased bought land and was being used by the family. So the assumption here would have been the wife bought the land when the husband was still alive. What if now there are documents showing that there's a joint ownership to this land?
Well, the laws of common tenancy or joint tenancy is that the survivor takes it. So in this case, that land or other property ought not to be even subjected to succession, because the deceased has passed on, and they were joint tenants in this land, and so the survivor takes that property.
Right.
Yes.
And that has already opened the door to our conversation. You mentioning who should be taking up this and all this, and this brings up a whole other question, many questions. But let's begin from the start. Just a whole brief definition of what succession in layman's terms really means, and the different types of succession that are there.
Now, succession is defined in very simple words as the transfer of property or wealth from a person who has died or a person who died to the living heirs, the living beneficiary or dependents. In legal words, we'll use the word devolution. The devolving of property or wealth from one dead person to the living people or persons that are succeeding him or her in the line of succession as defined, as adequately outlined by the Law of Succession Act.
Does it also define what a property in this case means?
Really, succession does not define what property is, but anything that is able to be defined or able to be included under property as we know it is actually devolvable. You can devolve anything that the deceased person owned prior to his death. And if you would wish to have the definition of property, we have the issues of matrimonial property. Those are the laws that really define what property is. The land laws, we have I think Black's Law Dictionary. Yeah. So in layman's word or terms, property here would mean things like cars, land, houses, or household goods, cattle. I mean, everything and anything that the deceased person owned that is usable and can be used.
Right. So in a case where the deceased had written a will, beautiful kind of will, elaborating what goes to who and all that. And as you mentioned, the cars, land, houses, alafu kwa will akakosa kuandika some details of some property, for example. So he wrote, let's say, the land, 3 acres somewhere, kaandika maybe the 2 cars go to someone, but then he left out the house, for example, some apartment somewhere. What happens in this case?
Now, usually succession is in 2 forms. One, where there is a will, and 2, where there is no will. So where there is a will, we call that testate succession, because there's a testamentary, there is a will. Where there is no will, we call that intestate succession. The person has died without leaving a will behind. Now, where there is a will can either be oral or written. Oral wills are nowadays very few, because they have been subject to bombardment in courts, because it take a lot of time or a lot more of evidence to prove an oral will.
With the advent of AI.
Yeah.
I mean, I'd imagine I can fake someone's voice.
Yeah, sure. We, of course, as Stanley puts it, with the current technology, somebody will simply just fake your voice and abrogate, or rather, a word himself or herself
Yeah.
a lot more from the rest. But you remember those old days where the grandfathers mostly, they would sit the entire family under a tree and put a radio tape when they begin to record. Ile shamba yangu ya huko, now that plot of mine down the stream, I give it to Stanley. The other one, I leave it to Akiro. So such kind, if they can be proved, that will be an oral will.
Okay.
Written wills are always the most common, but written wills always there are rules of putting down a will, and it is quite important that before you put down a will, you look for an advocate or a lawyer of reputable stature to be able to do you a well reasonable will, because so many wills have always been revoked in the country and across the globe because of lacking the basic principles of law. And which are these basic principles of law? A will always has to be dictated by or written by the testator, meaning the deceased person, himself or herself, that is prior to his or her death.
Okay.
And being that it is a will written in front of people, it must not be under duress, it must not be under coercion,
Right.
it must not be under undue influence, and the testator must not have been intoxicated at that given moment of dictating the will.
Right.
And the will,
Umepiga kakitu.
yeah, siku umepiga kakitu ndio anze yule kijana amenisumbua sana, yes, simpei kitu. No. You have to be sober. You have to have a sober mind.
Okay.
A will also has to be written in front of two adults of independent, they are not dependent on the estate.
Right.
So they are independent adults. And they also have to be of sound mind.
Okay.
You can't just pick mad people around and then you. So they are the ones to attest to this will by witnessing, signing the will. And when the will is at some time opened, they will be there to confirm that, yes, I witnessed this will. He was in his good state of mind, and this is how he wished his will to be devolved. So usually what happens is that the will be written, but then the deceased person, prior to his death, would maybe tip a member of the family, or literally depend on the witnesses. That once I'm gone, please inform my wife that the will is with my lawyer.
Okay.
Yes, or he'd go and confide in the wife and say, I have left a will with a lawyer, so once I'm gone, you can proceed to the advocate's chambers to get the will, or the advocate himself will tip the family.
And Okili, because the elephant in the room in our conversation today, hii chunk enye tutakuwa tunazungumzia is now the estate interference when it comes to relatives huku nje. So this person, wacha tumuite Charles for example, alikuwa na shamba, mali, alafu akatuacha. Now before, as you say, he had the tested succession, alikuwa ameacha will, ameandika will, but then hakuwa ameambia watu wengine aliandika, maybe alipatia this information to the wife, and also obviously now the lawyer knows. So back to what I had asked you now previously. So Charles, hypothetically, in the will did not indicate 100% of his property. Alieka, let's say 80%, the 20% hakuandika. And then, so that's number one. Number two, how will his relatives know that there's a will, for example?
Yeah, okay. In terms of wills, sometimes they are so much concealed that it's difficult to know that there's a will. What the law requires that where there is no will, you go intestate. But up to the point when the will is discovered, the intestate succession will be revoked. And the testate succession will commence, because priority is given to the wishes of the deceased. The priority is not given to those who are receiving his estate. Where the deceased has awarded 80% in the will and left out a few, probably because of one or two reasons that are maybe probably best known to him. If these other estates are discovered, then these other estates, after the succession with will annexed, that is under P&A 78, petition number 78, form number 78, the remaining estates that were not devolved within the will undergo intestate succession, where equal share will be the order of the day. Yes.
Right.
Yeah. Or if the family agrees that within the will, there is one person who was awarded very little, and the family agree that, yeah, really, this remaining one, let's add this other person, you'll just make a very simple application and attach it to the testate succession, and the court will always agree with the wishes of the family after the wishes of the deceased person. So it is the deceased person first, then the family, then the law. So where there is no will, then the wishes of the deceased person cannot be established. And so it is the family to sit down and share out the property. If they fail to agree, then the law takes its course. And the law is a sharp sword, it's a sharp knife. Everything equal, not equitable, equal.
What's the difference?
So equitable, it means maybe at the time of your of sharing out this estate, maybe some member of the family already has 30 cars, and the other maybe has some serious apartments. And so we say that the deceased has left maybe some 2 cars and 2 apartments. So we'd give the one without apartments the apartments, and one without the car, so that you come to par. But equal, it means regardless of your status at that particular point, what is available is cut into half. And if it is not half, maybe you are 5 people, it's cut into a fifth. So kila mtu anapata the equal share of that portion. But equitable is to raise the one at the lower to be at par with the one that maybe is above the rest. Yes, yes.
Does gazettement of this will, for example, happen as well?
Where the will has not taken into consideration the equality and equitability of the devolution of estate, yet and the court establishes that the will is valid. Remember, before the court adopts the will, the validity of the will has to be put into question, where capacity of the testator, state of mind of the testator, witnesses, and the time of the death, everything is put into consideration, and then the court adopts the will. Even if everybody was being given 3 cups, and then there is only one person who has been given a half a cup, the court will not interfere with that.
All right, interesting. And I can see some minutes to 1:30. Some beautiful time for you to work a credit or to pigia simu. The number is just on your screen, 0795 045 864. We'll be glad to hear your voice. When you do, call us, tell us your name, where you're calling us from, have your TV off kindly, and then utuulize swali. Whatever English or Swahili, then Wakili will be answering that for you. You can also text us on our WhatsApp number, 0793 267 279. 2047 is our SMS number. Even as you continue, because you addressed that whole bit of now this family, Ikae Chini. Now this is for the interstate, when there's no will. so that we really try to understand when this family sits down and they're trying to even see for that bit of kama ni 20% yenye the deceased hakuandika, how do we share all this? So the Law of Succession Act, if you can kindly have the infographics of this as well, just taking a look at what, let's say, the types of succession really are, but then also focusing on ile order fulani yenye inakuanga. So even as we also take a look at this, help us understand when a deceased passes and aliacha, let's say, the spouse with children, those kind of scenarios with children as well as without children. But even before we get into this infographics, I'm being told we have Joy kutoka Murang'a. Joy, habari asubuhi. Hello Joy.
Yeah.
Habari asubuhi.
Mzuri sana. Nilikuwa nataka kuuliza lawyer.
Ehe.
Kuna mtu wa familia alikufa.
Okay.
Na akaacha will.
Akaacha will.
Hiyo will. Ilikuwa imeandikwa 2021.
Okay.
Na akasema mwenye alikuwa witness wake. The time ilikuwa inasomwa, witness akasema yes, anaijua.
Okay.
But after that watu watoke nje, witness akasema haijui.
Okay.
Hiyo nayo inaweza endaje?
Interesting. Asante sana. Joy, wacha tutakuwa tunapata jibu kutoka kwa wakili sahihi. Some interesting dynamics there.
Well, Joy, that is an interesting portion that the family has gone through. Without the confirmation or validation of the will stands invalid. So if the alleged witness to the will comes to court and says that I do not know this will,
okay,
then the court has nothing to do but to invalidate the will, and the succession will proceed intestate. So it will be taken as though the deceased left no will.
Right.
And so intestate rules will proceed, where the family will either agree on how to devolve this estate, or the court's knife will swing into play.
Though Akili,
yes,
just to understand what Joy was saying.
Yes.
So in court,
yes,
in front of the judge,
yes,
this witness says yes, he will, I recognize it 100%. Wakitoka hapo nje, wakitoka kwa gate, anasema hapana, he will, sijui.
Unless
does the family now have to again go back, and what happens there?
Unless the witness revokes his testamentary or amends his statement in court, what is on the court record carries the day. So if after the court the witness indicates that the witness indicated in court that he knows the will, he attested to the will, he had the deceased in his sound mind dictating all these things, the deceased signed, and then he also witnessed the will, that is a valid will in terms of tested succession. However, if after giving all these and then he goes to tell the family that hata hiyo will sikuwa naijua, those are treated hearsays.
Okay. So in layman's term, hiyo ni stories za jaba.
Hizo ni stories za jaba.
All right.
Yeah.
Thank you very much, Joy, for calling us. You can also call us as you're watching us, or tell someone else to call us if they are involved in all these situations. Someone in the family passed away and they left a certain amount of property, na familia inajaribu kuona hii property tutagawana aje. Either will ilikuwa ama haikukuwa. Turushie hizo maswali zote, wakili will be answering them. Utakuwa unaona namba hapo chini kwa screen, so tupigie simu, lakini usi reverse call. On WhatsApp as well, the number is there. So before the call, I wanted to take a look at some infographics ya Law of Succession Act, ndio pia utueleze inamaanisha nini. So first of all, if there's one surviving spouse left, but then no child or children, as you can see there, the surviving spouse shall be entitled out of the net intestate estate to 1, the personal and household effects of the deceased absolutely, And number 2 as well, the first 10,000 shillings out of the residue of the net interstate estate, or 20% thereof, whichever is the greater, as well as a life interest in the whole of the remainder. So even as you give us a brief of what this means, Nakama, it goes to a polygamous kind of marriage where this man passed away and left 3 wives.
Well, in terms of checking number of the vastness of the estate, we are now looking at intestate estate.
Okay.
Because testate estate, you find that whether he has 10 wives or 30 wives, he has considered all his wives and children within his will. And if he didn't consider any in the will, then the will be revoked. Okay.
Right. And I know we'll come to analyze it further, but then let's pick this call all the way kutoka Narok. Jackson, habari asubuhi.
Salama sana.
Asante sana kwa kutupigia, tumefurahia kusikia sauti yako. Uko na swali au ni maoni?
Niko na swali kwa.
Yes, uliza.
So I come from interpretation community.
Kidogo tu Jackson, rudia swali tafadhali, na I think unaweza weka simu mbali kidogo na pali huko ndio tukusikie vizuri.
Okay, ndio nasema.
Yes.
Having come from Masai community, kuna issue moja. Kuna wazee wa asal demon on the side.
Endelea, lakini hatukupati vizuri Jackson. Sijui shida ni network kama ni
Atoe loudspeaker.
Okay. Hello.
Yes.
Endelea, tunakupata sasa.
Ndio nasema, so that pamekuwa na this issue that keeps rising when it comes to inheritance.
Okay.
Kama mali ambayo imeachwa.
All right.
And unapata mzee alikuwa na maybe sijui mwite side dish on the side. So and then you find that these people in the name of kupata a part ama a portion of the inheritance,
right,
wanna find court orders to hold the burial.
Okay.
So inakuwa burial haiwezi kuwa held because of these people and wanataka inheritance. So how are people supposed to go about that things? Because I know it has affected a lot of people. Na major inheritance. Now you find probably this lady is not recognized. Now I don't even know where it's going in regards to mambo ya community marriages. Ama marriages that are not formally organized.
Right.
Yes.
Sawa sana, asante sana for calling us and salimia sana watu wa Narok. Wakili, he brings about something that we did see a couple of months ago of the burial, the proceeding events of the burial of one of the renowned athletes in the country when he passed away. How do you go about this?
Technically, if anybody has passed through law school, that is usually the first case scenario. Because there once was a lawyer by the name S.M. Otieno, was a renowned lawyer in this country. He got married to 2 wives. He had Wambui, and he also had another Luo wife. And so the question came to, where is he to be buried? So when you talk about stopping of burials, is a question of who has the right to bury. The law has always been the person with the closest chain or channel, closest link to the deceased person. And here, although wives are normally considered non-relatives when you are gone,
okay,
but the law always upholds that your wife is the closest you have. Now, when this person had 2 homes or 2 wives, then next we look at your kinsmen, where you come from.
All right.
Assuming the person had a house in Mombasa and had a Mudigo wife, and then the person was a Kisii, and also had a Kisii wife,
Okay.
and had a home in Nyamira. So if there is a dispute here, the Mudigo wife will have a bit of problem having the body.
Okay.
The body will have to be taken to Nyamira. If the deceased did not indicate in his will or to anybody his wishes, like we saw with our general.
Yeah.
He gave a wishes how it's supposed to be buried, when
Specific.
supposed to, specifics.
Yeah.
If the deceased didn't leave those specifics, then the court will give the body to the person with the closest link, and that will be the wife. Yeah, if there are no wives, then his children. The wishes of the children will be taken in, and if there are no children, then the relatives. That is the father, the mother, the brothers, or the uncles. So those people have got the right to stop the burial if it is not being conducted at a place they wish. And so in such scenarios, the court will just have to quickly establish who has the closest link to the deceased.
Interesting. Yeah. But then okay, I'm being told we have a caller. Let's make this caller. I didn't get the name, and is it Makweni? From Nakuru. Amesema jina withheld. Habari asubuhi. Thank you very much for calling us. Uko na swali?
Good morning.
Yes, good morning.
Uko na swali?
Yes.
Swali langu ni hili. Okay, our mother died while we were young.
Okay.
Alafu, our father married another lady with 5 children, 2 sons and 3 girls.
Right.
At that time we were young, so we didn't even know anything. But over the years we have grown, we have come to realize some things that didn't go right.
Okay.
Now, we came to know that this newly married lady eventually alipewa shamba fulani. Of which there is no property that wasn't there by the time our mother is dying.
All right.
All the property was there. What happened is that this lady came na watoto wake na wakapewa shamba fulani.
Okay.
So what we do, we try to follow, at least realize just because we feel, now that we are grown, we feel that it wasn't fair. Here apewe property yenye amepata, baba walitafuta na mama. Okay?
Yeah.
Yeah, and all the children only, they got 3 other daughters, but the other children are from another relationship that huyu mama alikuja nao.
Right.
So we've been trying to follow, but we find that mzee anakuwa mgumu, anastiki ya kwamba vile yeye alishampatia ile shamba, that is all. Is there a way we can get about this in order for us to really just, hata kama atapewa share, we feel that hangepewa the whole it is 5 acres.
Okay. A quick one, a follow-up. Was there any will that was left ama hakukuwa na will?
Okay, baba angali hai. Baba angali hai, mama ndiye alienda. Wakati mama alienda, things got wrong, lakini baba angali hai na we don't know ni wapi alimwandikia kwamba amempea hii shamba. We have never seen any will or any transfer or anything.
Right.
Yeah.
Right. Asante sana. Thank you very much. Name withheld again from Nakuru. Some interesting bits. I'd like us to focus on Ian Nakuru, what he's raised, and then we go back to what Jackson from Narok, what he asked about the come we stay kind of marriages and what it brings about.
Good. Stanley, what Nakuru person, the Nakuru caller, let me call him like that, has raised is always pertinent. It is something that occurs more often in our country.
Okay.
One thing that the country needs to sit well with is that as long as a person is living, he has the right to use and misuse. Remember, I'm talking about the right to use and misuse his property as he wishes.
Okay.
As long as he's alive. However, if it is established that this property was gotten by the deceased mother of these children, then the family will have to question the ownership of the property. Take it back to the mother. This is now not succession. This is an ELC question. What normally most lawyers make a mistake of.
And because I know you're used to the short forms of it, ELC nini?
Oh, yeah.
Environment and Land Court.
Yes, that is Environment and Land Court.
Yes.
It's a specialized court that deals with all matters specific to environment and land.
Right, carry on.
So what we most lawyers do is that when a person is dead, we approach the succession court to establish that this land belonged to the deceased.
Okay.
That is not within the purview of the succession court.
Oh, okay.
You go to the Environment and Land Court to establish the proprietorship, the ownership of this land first. If the ELC court, because I've defined it, has established that this land belongs to your living father, I tell you, you have nothing to bar him from even using his land to drink.
Interesting.
But if the ELC court establishes that this land belonged to your deceased mother alone, remember alone, if they were joint tenants, then the survivor takes it, meaning the father will automatically take it. But if it was for the mother alone, and the ELC court has established that the proprietorship of this land belonged to the mother, then it will be taken back to the estate of your late mother, meaning the land's registrar will be ordered by the court to cancel and revoke any new title that has been issued upon the death of your late mother, and then the old title in your mother's name will be retained. Then now you proceed to the succession court. So the succession court's mandate is simply to devolve the estate. Once you have established that the property you are bringing to court belong to the deceased person, yes, they will take jurisdiction to devolve this estate. If there is no establishment of ownership of the estate, the court has lax jurisdiction ab initio from the beginning.
Right. Today we're going to be having anonymous callers deciding to have name withheld, rightfully so, by the way. You can obviously call us and tell us what a name iko withheld. We have one from Eldoret. Habari asubuhi, and how is Eldoret looking like? Eldoret City today, actually. Do you have a question for us?
Yes, I have a question.
Yes.
There's a situation where we have one parent passed.
Okay.
Yes, so the parent is the father. And then now he had two wives.
All right.
That is two homes,
Okay.
So the two homes had different properties, that is land and everything.
Right.
Now, we finished everything, burial and everything, but now in sharing the properties is where the problem comes in.
All right.
In the first homes, first household, the properties are a bit small.
Okay.
The land in size compared to the second one.
Right.
Which is the second one is the small.
Okay.
Now, are we going to go about? Maybe, but he had said already that this land belongs to the second wife, and this one belongs to the big one,
right?
The first wife.
Okay.
But now, in terms of size, the big wife is smaller than the second wife.
Okay.
Yeah.
Right. Thank you very much for that question. Quite an interesting dynamics and quite a solid one. Thank you. Salimia sana to Eldoret.
Yes.
Wakili, even as you answer this, because it ties to what Narok caller Jackson had asked about the kind of come with stay marriages and how to separate some of these properties therein. What happens here?
Well, I would say it depends on when the father died. If the father died post 25th August 2017, then the question of the validity of the marriage will have to be established by the family court.
Okay.
And if this is established, that the Kamwe stay would actually result into a viable marriage, then the woman will be considered a wife per law. If the deceased died past 25th August 2017, then the question of whether there is a certificate of marriage would arise. Because after then, the only proof of marriage would be a certificate of marriage, unless it can be established by the court that the deceased died when you are in the process of acquiring the same, and you can establish to the extent that the court can hold that, but for the death of the deceased, this marriage would have been registered. But means except that the deceased has died, then this marriage would have been registered.
So that is in the case of now the Kamwe stay kind of marriages.
This Kamwe stay kind of marriages. So yes.
Okay, we haven't yet gotten to the Eldoret caller because we have another caller, Abdul from Nairobi.
Right.
I'd love us to collect a couple of his calls, and then we allow also Akili to answer you, and then we continue picking this call. So let's pick this one up in Nairobi. Abdul, habari asubuhi.
Mzuri.
Asante sana kwa kutupigia. Uko na swali au maoni?
Kuna swali?
Yes.
Kuna vile sasa sisi tuko na ploti kuna Nairobi.
Okay.
Bado tuwezi chukua title kwa sababu hatuelewani.
Aha, kwa nini?
Kwa nauliza,
Kwa nini?
Siji ni ujinga kama nini? Sasa ninauliza kama ndio vitu ndio ploti isiharibike. Mtu anaweza kurandiwa ashikilie hiyo vitu kwanza. Kabla watu wanaelewana.
Alright. Ndio pia mimi na wakili tukuelewe vizuri. So issue ni nini exactly?
I understand him.
Oh, okay.
I understand Abdul.
Alright. Wakili amesema amekuelewa kabisa. Asante sana.
Abdul, kabla hujaenda.
Yes.
Wazazi hawako wote.
Hawako wote.
Okay, sasa you can just log off as I answer you. Let me start with Abdul.
Okay.
Abdul, kama hamwelewani, then at least two of you when you wanaelewana, if not wote hamwelewani, then either one person
sio wote
can file for succession.
Yes.
And seek an order suspending any dealings in that land until all questions that the family have that brings the differences are established by the court.
Right.
Na hata kama mtakuwa mmeelewana, the court will tell you this is what the law dictates, and you will be ordered to abide by the rules of the law. But you can file for succession. I know I'm not allowed, but if you permit me, Abdul, you can visit us in Westlands. We can take that for you.
Right.
The first one I've talked about. Yes.
Thank you.
You're welcome.
Yeah, so Abdul, what you can do is stick around. Even as you're going to be wrapping up this conversation, he will be atakuwa anapatiana simu, namba ya simu na pia contacts. That goes for each and every one of you listening to us this morning. So umejibu ya Abdul, even as we, I know there's so many callers, wengine wanaweka credits ayo tupigie simu because this happens a lot.
Last time my wife complained. She tried calling.
Well, it's the nature of the job.
Yeah, I understand.
Let's tackle Eldoret's caller. So in case you're just joining us right now, a brief of what Eldoret caller had asked. There's a parent, the father is deceased, and there were two wives here. That means two homes. Both of the two homes have different properties, but then here's the shift here. The first home, who is now the elder wife, has a smaller property compared to the second wife. And now wakati wa kushare these properties among the children of these two houses and these two homes, they're wondering, hey, tufanye aje?
If there is no will in that home, then the rules of intestacy...
And I forgot to say, so the father left a will, but then did it orally.
Then it will be a question of proving the oral will. Approach the court with a will or codicil annexed, then let the court validate the oral will. If it is validated, then the rules of testacy, the rules of succession with the will take place. There is nothing the family will have to do. Whatever the father gave who, that is what will be upheld by the court. However, if the will is invalidated, then succession intestacy, where there is a family with more than one home, is that this estate will be devolved into those homes, taking into consideration of the number of children per each house.
Okay.
If house number 1 has only 1 child, but house number 2 has 10 children, then automatically house number 2 will take the biggest share, actually a bigger portion. Because remember, wives are only entitled to a portion of the estate and whole life assurance. Whole life assurance to mean that as long as she lives there, she is entitled to any part of that estate as long as she lives in that estate. But the people to whom the junk of the estate devolves are the children.
Right.
And the children here, I mean both girls and boys, or ladies and gentlemen within that home. So the court will consider how many children are in the first house, how many children are in the second house. But if the family sits down and agree, and the smaller house sees that enyewe, sisi tuko na shamba kubwa, hawa wanaumia, wacha tuwaongeze kitu kidogo, I assure you the court will uphold that. I assure you for a fact, for the years of practice succession, the court will uphold that.
Right. So I can see my super producer ameamua tuongeze some very good time. So I think we can continue. That means obviously you watching us, continue calling us this morning. The number iko pale chini kwa screen yako. Back at home, there's a relative who passed away, and there's so much fiasco na drama ya hii shamba yenye aliacha itakuwa shared haje. So far we've received a number of callers in case want to join sahi, and Wakili has been answering them. So before Abdul called, we were trying to tackle your story, another woman, the other woman in this picture, and you're giving us this particular dates, and I can see even people are wondering what happened on that date as well, because what this caller, Jackson from Narok, was saying was stories of inheritance, where there's another woman who goes to court to block the burial proceedings from happening, and history of the whole succession when it comes on board. This whole dynamics as well. What really happens here?
Now, you see, what Kenyans know is that you get succession rights when you're included in the burial processes, because that means you are closer to the deceased person, and that means that you are qualified for inheritance as per law. But really what happens that even afterwards you can establish your link to the deceased as per section 29A, B and C of the Law of Succession Act. What does section 29 talks about? It talks about dependency. These are the links of succession. So section 29A gives these groups of people rights to succession without proving dependency. That is the wife, former wife, and children. These ones must not prove that the deceased was maintaining them prior to his death. Then section 29B, we have the grandparents, the parents, uncles, the children the deceased adopted as his own. These ones must prove that prior to the deceased's death, they were depending on the deceased person. As such, they will be qualified to this estate. And then section 29C talks about the husband of the deceased person. Because mostly we look at succession in terms of the man. But if the woman is also dead here, the husband is taken care of in section 29C.
Okay.
But then the husband must prove he was a husband and was depending on this woman prior to his death.
Right.
And so if this come-we-stay woman has got, he has been left out in all these procedures, then the succession court will always question if indeed you are a wife and he was buried and you are not there. That's akin to something we have personally as an advocate in our family that we are grappling with. You never buried my father, never buried my mother, never buried my brothers, and then you come when I am 31 years old, then you come to tell me that, your father also married me. Honestly, Stanley, you cannot accept that. So these women usually run to court to be included in these procedures for purposes of recognition at the time of succession. Remember, I started by saying the deceased person will always be given by the courts, if there is a dispute as to who is to bury the deceased person, if it's a man or a woman, to the person with the closest link.
So it means that there's a certain hierarchy.
Yes. We have the certain hierarchy here. We have the wife and children first. And then after the wife and children, then we have the parents. After the parents, we have the grandparents. After the grandparents, then we have uncles up to the 6th degree of consanguinity.
Right.
How the great-grandfather, the link to the great-grandfather. So it is the father, the grandfather, so anybody within the grandfather's bracket, and then great-grandfather, anybody within the great-grandfather's bracket, up to the 6th degree of consanguinity.
Right.
If after 6th degree of consanguinity, there is no established person who is rightfully able to inherit this estate.
Okay.
Or even if the 7th is found, then this estate will go back to the state.
Okay. Nataka tuende all the way to the Nyanza region in Kisii, specifically where there's so much land tussles. Johnston, habari asubuhi?
Good morning.
Good morning. Watu wa Kisii mnaendeleaje?
Wako salama.
Do you have a question or a feedback?
Yes, a question.
Yes.
A question to Wakili. A question to Wakili.
Yes.
Yeah, there's a situation. There's a situation where you have the parents are not known where they are.
Okay.
There are whereabouts of the parents.
Right.
Especially the father.
Okay.
How can you start succession without knowing the parents with the whereabouts?
Interesting.
Yeah.
Thank you for that.
I didn't hear him clearly.
So he says that there's a situation where the parents are not known, and specifically, for example, the father is not known. So how do you start the succession process if you do not know where the parents are?
Then how do you establish the property you want to succeed? That's very difficult in law, but unless you see there is some property, then there are legal registries in the land. Go and establish who are the owners of this property, and then the names you find there, go and establish whether you have a link to them. But if you have no father, you have no mother, like you do not know your parents.
Yes.
Like you grew up in the streets for the street children. And then you want to do succession. Whose property are you going to do succession on?
So that means you need a certain documents.
Yeah.
When you're starting this process.
Exactly.
What are they?
No, when you are starting succession, you'll need the death certificate of the deceased person.
Okay.
You need a letter from the local chief.
Right.
Not where the person, was, or rather where he has resided, but it's where he hails from. Mawe
So-
chief wa nyumbani.
So ushago.
Yes, chief wa ushago. Apeane letter from the chief, alimujua huyu so and so, hail from here, just to ascertain that the chief knows this person. And
Okay.
the chief will also list the heirs.
So for example,
Yes.
for about 3 generations,
Yes.
this family has been in Nairobi, for example. The third generation does not recognize any roots uko ushago. What happens?
Then the local chief of the place of residence can do that.
Okay,
Yes.
all right.
So priority given to the chief of Shago, and then the local chief of place of residence takes the second priority.
So ukienda kwa chief, what do you tell the chief to give you?
You just tell the chief, I need the letter for succession. Some chiefs know it, but some chiefs, we always have to tell them what kind of letter we need.
Okay.
Some of them do write very long letters and say, please accord them help, they are needy. This is very simple. There's a deceased person here. He hailed from my locality. Prior to his death, he left the following people. Some people also, the chief asks them for deceased person's estate's property. Please, the chief has got no right to devolve land. He has even no right to know those property. What you simply need to do is the chief to know to inform the court that the chief knows you. So you can even guide the chief on what to write.
Okay.
Tell the chief, I want a letter that indicates that my father is dead, and prior to his death, he left the following people and they hail from your locality. That's all, period.
Right. Before you even continue about that whole conversation here, Chief, because there's so many questions on that. Na I'm going to call from Murang'a. Habari asubuhi.
Mzuri sana.
Asante sana kwa kutupigia. Do you have a question ama ni feedback?
I have a question.
Yes.
I have a question.
Yes, yes.
How is all will?
Sorry, how do you?
How is all will?
How long do you?
How is all will?
Okay, right. Wakili amekupata. Thank you for calling us this morning. Yes.
Yeah, they established the issues of wills from the beginning. An oral will can either be dictated to people or can be recorded. But then it must be established and agreed upon by the people who allege they had. And if a majority of them can establish that they had the deceased person devolving his land orally, then the court will uphold that.
Right.
So there are parameters of proving an oral will, the capacity of the deceased person. There must be no member of the family who was left out legally. Of course, a criminal person must not benefit from the criminal acts. So, for instance, if there is a son who has known that there is a will, maybe has been tipped by an advocate friend that the father left a will, but kuna gari na mali na nini mingi sana, then he goes and finishes the father so that he may inherit this. You will not inherit that if you are not supposed to benefit from your criminal activities.
Right. Hold on to that bit. You've raised a whole interesting conversation. So far, you've received about 7 callers. You can also be the next one after this short break. So do this. Weka credit sahi. The number is on the screen. I hope you may save 0795 045 864 and call us so that you get clarification on this conversation. The whole estate interference with relatives kama mtu amewaacha. Tunarudi saa hitu.
Hey there, friends. Welcome to Kids on the Block, where fun and imagination come alive. We dive into magical world filled with exciting adventures and awesome friends.
What position were you in?
I was number 2.
What position were you?
Number 1.
He decided to cross the bridge by his house and look for food on the other side.
We're going to do half cup of chocolate chips, and the other one, we're going to do half cup of the blueberries.
So, grab your imagination hats and get ready to explore with us. Join us every Saturday at 9 a.m. for new friends, amazing stories, and tons of laughter.
Join us as we explore the journeys of those who defy the odds and break barriers. We dive deep into the stories of triumph.
Sometimes when parenting a child with a special need or whatever disability, family life becomes a bit complicated and you may end up raising the child on your own.
Here, we inspire.
I have a farm which one we showcase with other dyslexic youths and autism how to farm.
Motivate.
It's never easy, but what we do, the best thing is to work with another parent who has an elder child than yours.
And break through the barriers one story at a time. Push your boundaries beyond the limit. Saturdays at 8 p.m. The Grind, where business meets brilliance. It's not just about the ideas.
I was working as a shampoo boy. I used to wash clients' hair on the sink.
It's about
Right, Karibisana, this is Morning Cafe. Before we continue the conversation about law matters and law of succession, I want to take you all the way to Eldoret in Uasin Gishu County. So about 50 minutes ago, the team that represented Kenya in the Paris Olympics jetted at the Eldoret International Airport. And since then, they have been having this whole procession heading to State Lodge, which is in Eldoret, for a whole grandiose kind of a reception. President William Ruto is expected to receive them. As you can see on your screen right about now, the fleet of Boda Boda riders just karibisharing them, wakiwakaribisha hapo into that to-be city this particular day. This also coincides with what is going to be happening. One of the biggest news for today, one of the biggest news for the residents of Eldoret. It is going to be conferred to be a city by President William Ruto. He is there. He's going to be there today. So that is what is happening. I don't know if you can just listen into some natural sounds and the ambience of what is happening there before Turudi. Probably carrying and on board this Paris Olympics. Since Monday, they jetted into the country at JKIA, different batches of them being received. Just remember, Kenya was #1 in the African continent, but then it was number 17 globally, receiving about 11 medals. So that is as far as it goes, just getting that kind of a grandiose reception into the Eldoret to be city today. As you can see, just the flag of Kenya being hoisted outside this bus, and they're making their way to State Lodge. So we'll be giving you and beaming you these pictures even as we continue. President William Ruto expected to host the athletes who represented Kenya in the Paris Olympics for 2024 at the State Lodge later today. They're making their way all the way there. It's quite a big moment for the country. All right, just a reminder again, we'll be giving you this live pictures as we continue. Now, in case you're just joining us right now, before the break we had about 7 callers, and the main focus really what they were calling us about was the succession process, each of them telling us the stories about how kule nyumbani, the kind of experiences they have received, because that is our main focus today. A relative passed away of yours, and this relative left property. Either aliacha will ama hakuacha will. There has been a whole controversy in your family kind of a setup, and you're wondering, how do we deal with this? You've probably gone to court, or you're thinking about going to court. Well, don't worry. We have an advocate of the High Court, Silas Akiro, here, who has been gracious enough to give us much of his knowledge so far. And previously, before we went on a short break, you're talking about how property that has been acquired through criminal means and all that. Kindly elaborate for us this.
Yeah, as I was saying, the rules of succession do not allow somebody to benefit from his or her criminal activities. And crime in succession has always been reported in this manner. Somebody knows that the father has left a will, or is tipped by that the father has left a will. And then maybe Ju anateseka or is having hard life and wishes to begin enjoying these estates of the father. He goes and finishes the father, kills the father in the hospital, and is of course convicted and found guilty of murder.
Okay.
Then this person will not be allowed to inherit from the estate.
Right. We have another caller, Patrick, all the way to Kisii. Habari asubuhi, Patrick.
Nzuri sana.
Asante sana kwa kutupigia. Kisii is one of those places zenye makesi ya shamba inakuanga nyingi. Uko na swali ya kutuliza leo ama ni feedback?
No, niko na swali.
Yes.
I have a question to the lawyer. And my question is, kuna kesi baba alikuwa na wanawake watatu.
Okay.
Alafu akafariki.
All right.
Baada ya kufa, hakuwa ameacha wili yoyote ya succession ya land yake.
All right.
But he left the title deeds to the brother.
Okay.
And the brother is not in good terms with the family, the 3 wives.
Wow, right.
In that case, what do you do? Because the brother is not willing to hand over the title deed, what do you do?
Okay.
Thank you.
Well, Patrick, before you go.
Yes.
Is the title deed in the name of the brother, or the name of the grandfather, or the name of your father?
The title deed is in the name of my father.
Okay.
But we have allegations that it went back to the name of the grandfather.
Okay.
So we may not, what is the procedure, what can we do?
All right. Thank you so much, Patrick. Now, there are 2 things here, Stanley. Either this title at adjudication stage, where the land was being declared an adjudication area and titles are being issued, the land originally belonged to the grandfather, but because the grandfather was dead at the time of adjudication, a long time titles used to be given, the land used to be written in the name of the firstborn in trust for the entire family. So if it is established that the firstborn son or the family of the firstborn wishes to inherit the entire land to the detriment of the rest of the family members, then an ELC court, remember I said, on ownership, it is not succession court. It is back to the Environment and Land Court. Will establish that the adjudication procedures were maybe not procedurally undertaken, or that the adjudication procedures were taken properly, but then the land was a trust land. And so if there is a problem, then this land will be cancelled, the title will be cancelled or revoked, and a new title will be issued in the name of the deceased, and then succession will be taken by all the members of the case.
Right. Patrick, I hope GB are here. From Kisii, I want to take you all the way to Machakos, where Meshach is. Meshach, habari asubuhi kutoka Machakos. Hello, Meshach, can you hear us?
Yes, I can hear you.
Yes, endelea na swali kama uko nayo ama ni feedback.
Swali langu ni kwa akili.
Okay.
Salamu sana.
Naongea kuhusu property ya my grandfather.
Okay.
Yeah, it's we have the succession case in court.
All right.
But among the properties zile tunaulizania, there's a property my grandfather had 2 wives.
Okay.
And among the wife, the younger wife, ule bibi wa pili, akuja akasema one of the property aliuziwa na bwanake.
Okay.
Wakati anasema hivyo sasa, lakini kuna hiyo property amerithi as the property za bwanake zikuwe shared, but at the same time anasema kuna title deed ya one of the properties.
Okay.
Sasa kwa hiyo one of the properties before my grandfather passed ilikuwa na issues. Mabibi wake walikaa chini na mama yake akakuja, mama ya grandfather akakalisha bibi watoto wake chini.
Right.
Wakaulizana where there were people, even my father was there.
Right.
So akasema hii property ni yake, lakini kuna issue kidogo ya pesa walibishana bibi mdogo.
All right.
Alafu atakuwa ataketu hiyo ataongea baadaye, lakini akasema property ni yake. Later my grandfather passed immediately na circumstances zilikuwa clear.
Right.
So then the title deed ikachange ikakuwa that property ni ya huyo bibi mdogo.
Okay.
Huyo bibi mdogo ambaye ni my grandmother, I met her before she died and we talked about that property. Akasema anataka kwa equally shared. In fact alisema ipatiwe grandfather, grandmother ule mkubwa I share the property between them equally.
Right.
So with time, my grandmother wote wamepata. So we have the side of my aunt, the step aunt, na my uncle.
Right.
We are in court, and the issue is your property.
Okay.
So I wanted to ask the lawyer, how do you go about this?
Right.
Because also there were this traditional tunasema clan. We call the clan.
Okay.
The clan meeting that was called. And their relatives, what they agreed about the property. Now they were talking about that one property because this woman, my grandmother, was asked kama hata Kikamba anaweza kweli inaitwa Kivintu kama kweli aliuziwa property na bwanake, akakataa, ndio wakashare property, akaambiwa wewe chukua property na nyingine. But since wameenda against that will, walikana wazee.
Right.
So hii property ni kama walicheza ukora wakapindua title deed kwa gang.
Okay.
Ndio upande yao.
A quick one, Meshach, kabla ukate simu. Since your grandfather passed away until now, how many years has it been?
It's almost 20 years, 24 years.
24 years, okay.
Yeah.
So asante sana kwa kutupigia. Wakili will be answering you right now.
Okay, asante.
Wakili, 24 years plus, they're still wondering how do we handle this?
Well, if 24 years have been uninterrupted, then the person who lives in that land uninterrupted really needs to apply for adverse possession. However, if the living has always been interrupted, they've been having these questions, they've been having how do we go about this, how do we solve this, then like I said, if that estate, if that case is in the succession court,
okay.
it is liable for being thrown out.
Right.
Because it's a question of ownership of this particular land. However, if it is established that indeed the transferred documents from is it the father to this other wife, or is it the grandfather this other wife, the transferred documents establishes that this land belongs to so and so, then succession intestate, I mean, you said they left a will, some sort of a will,
yes.
And the people who can establish that, you can do succession with a will, and then you go and say the will was oral, and this is how it happened, and then the court will try to establish where the will is valid. If it is valid, then succession will take place in the name of the woman, owner of the land.
Right.
Yes.
Right. Wakili, we have about 4 minutes to wrap it up.
All right.
So before I get your last thoughts and just a summary of what we've discussed, and I hope back at home, whatever you're watching us from, umekukiandika notes because there's some amazing analysis you've given us. But kuna kuga na ile swali moja yenye Wakenya wanatakanga kujua. Yes, tapitia process yote because you've also told us the documents as well. But mtu anashangaa bei ya hizi vitu. The total cost of this, how much will it be, the whole succession process?
Well, in terms of costings, we normally look at the filing fees, the legal fees, and disbursements. Now, disbursements here are the things you're going to do within the errands, moving to court, coming back, and what have you. And so, filing of succession cases is usually 2,000 shillings. However, filing, legal fees, it's between you and your advocate, subject to the minimum put by the advocate's remuneration order.
Right.
I do not wish to have lawyers with ribbons at my office.
and much outside our office of the Kukujie. Before we wrap it up, I think a final call, because time is really not on our side. Joy kutoka West Pokot. Joy, habari asubuhi.
Hello.
Hello, Joy, habari West Pokot.
Salama sana.
Asante sana kwa kutupigia.
Asante pia.
Uko na swali kwa wakili? Uliza tafadhali.
Kwetu nyumbani baba alikuwa na wanawake 4.
Okay.
Na ikafika mahali
right,
tukakubaliana igawe kwa watoto tu, si kwa wamama, kwa sababu iko mama mwingine alikuwa na mtoto mmoja, mwingine alikuwa na mmoja pia, mwingine akawa na 6, mwingine na 11.
Right.
Sasa tukasema ikienda shamba kwa wamama ilikuwa 28 acres, itakuwa 7 kila mama na watoto wengine wataumia.
Okay.
Sasa tukaamulia iwe tu iko. Kila mtu apate tu 1.5 tukapata hivyo.
Okay.
Tukarudi kwa plot. Plot ilikuwa 3 za baba.
Okay.
Sasa tukasema watu waingie watu 5. Tuko 17. Watu 5 ndani. Sasa ikafika mahali hizo plots badi koti rule kwa watu 5. Ikarule kwa ikaingiza watu wengine 5 pande, alafu ikampa mmoja plot moja full.
Okay.
Na ikawacha watoto 5 nje.
Okay.
Hiyo ndio swali tu.
Sawa. Asante sana.
Na huyu ndugu hata mwaka jana amekufa.
Condolences.
Sasa bibi yake amerudi kukasania hiyo plot ya baba.
Sawa.
Sasa koti iliwacha watu 5 nje, ikampa watu 5, ikampa ile watu wangeingia 5, ikampa mmoja.
Okay.
Sasa watu 4 tuko nje.
Pole sana.
Kotini haikuonyesha hii watu 4 basi wanaenda wapi?
Sawa. Pole sana Joy. Kwa hiyo wacha wakili atakuwa nakupa jibu sahihi.
Asante.
Yes, wakili.
Stanley, that is a question of Section 76 of the Law of Succession Act, where the parties aggrieved with the devolution as by court, then they should file summons for revocation, but then they should establish that certificate of confirmation of grant or grant was issued by concealment of some vital information, by falsehood, and all those that have been established under Section 76.
Right.
And so Joy, katika familia tunasema ya kwamba bado mkuna nafasi, mnafaa mrudi kotini, mwambie koti ya kwamba hii na hii haikwenda vizuri, na tungependa hii grant yote ikuwe revoked, na tuanze upya from the place where the family had agreed.
Asante.
Yes.
And wakili, I know because of about 12 callers who've called us, pia watakuwa na more questions.
Sure.
Tupatie just your number, just your contact, alafu tufunge.
All right, thank you so much. My number is 0717 653 746.
Again?
0717 653 746. Akiro and Associates Advocate. My name is Silas Akiro.
Thank you very much, Akiro Wakili. We do this every single Thursday between 8 to 9 thereabout. Kukupatia